first case to come before the court is State of Ohio v. Timothy James House. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time for rebuttal, please let me know as I'll keep you track of the time. The arguments are being recorded, so please introduce yourself, keep your voices up, remain behind the podium. You should not use the names of victims or children or minors during your argument should that be relevant, and you can refer to those folks by initials or general terms. The judges have read your briefs, and we are ready to proceed when you are. And I would just ask, counsel, would you like to reserve time?
I'd like to reserve 5 minutes.
Very well, then you may start when you are ready.
May it please the court, Timothy Martino on behalf of the state of Ohio. The appellant in this matter, we are asking that this court reverse the trial court's decision dismissing the having weapons under disability count of the indictment because the trial court erroneously determined that analyzing the issue of whether the defendant was a fugitive from justice was a legal question rather than a factual determination, which necessarily involved an analysis as to the quality and quantity of the evidence that was presented. And secondly, that a fugitive from justice was within the confines of the having weapons under disability statute does not require that a person leaves a particular jurisdiction. With regard to the pretrial motion that was filed to dismiss the having weapons under disability count, a trial court is able to rule on a pretrial motion, but only to the extent that the issue is capable of being determined without a trial on the general issue. Criminal Rule 12C2 allows a court to examine an indictment to see whether or not it's defective, but only, again, to the extent that the trial court does not have to engage in an analysis of whether those facts could be determined only through a trial. So that means that basically the trial court can look at whether the indictment, whether that person is subject to the statute, and if they are subject to the statute, if there's no set of circumstances by which that person could violate the statute. That was not raised as an argument here. Instead, Mr. House simply said, I am not a fugitive from justice because I never left the jurisdiction. And the court found that, therefore, that is an element of the fugitive from justice element of having a weapon under disability, that you have to, 1, either be suspected or convicted of an offense, and that 2, you're aware law enforcement is looking for you, and then 3, you intentionally take some step to elude law enforcement. And then they added that 4th requirement that you leave the jurisdiction. But they also found that Mr. House could not have ever violated the statute of that section because he didn't leave the jurisdiction. That is necessarily an engagement into the facts of the case, not just a legal argument. So based on Criminal Rule 12 and the case law that supports that a court cannot engage in an analysis of what would be the general issue at trial when determining a pretrial motion, the court in this case exceeded its authority and should not have dismissed the having weapons under disability based on that. The proper procedure would be to have a trial and have the defendant raise a Criminal Rule 29 motion that they could then challenge the sufficiency of the evidence presented, and the court could engage in that analysis of what facts were presented and whether that was legally sufficient under the elements of the statute. Within the context of the fugitive for justice element of having weapons under disability, that is not defined by statute, but the state would argue that following the rules of constructions under Rule 1.42, you should give words and phrases their common grammar and usage, and then looking at the dictionary definition of a fugitive, that just means that someone has tried to escape. One of those ways is by fleeing the jurisdiction, but is not required. The OJI 523.13a for fugitive from justice under the having weapons under disability statute has the 3 elements of suspected or convicted of a crime, actively being sought by law enforcement, and then taking an affirmative act to elude. The comments to OJI specifically refer to the cases out of the 8th District and the 2nd District, State versus Marsh and State versus Cherry, which applied those same 3 elements. There is a notation in the OJI that the court was not adding the 4th element that 5th District and State v. Hall added, which is the fleeing the jurisdiction element. The trial court further looked at a case from this district in Atkins, which analyzed the fugitive from justice definition in the context of the extradition statute. We would argue that this case is distinguishable from Atkins because this case does not involve the extradition statute. 296311 also does not include a definition of fugitive from justice, but it does talk about someone being in any other state. Necessarily, the extradition statute would have to always require that someone left the state, otherwise they would not need to be extradited. So the plain language of the extradition statute, as well as the intention of the legislature, clearly would require that a person left the jurisdiction to fall within 296311. But there's nothing to indicate any legislative intent in having weapons under disability statute that a fugitive from justice would also have that element that is not in the statute, and that only one court of appeals has added, which is that the person has left the jurisdiction. So the state would argue that the trial court erred in dismissing the indictment based on the fact that it engaged in a factual analysis, and two, that the definition of fugitive from justice within the confines of having weapons under disability does not require that additional element that the person has left the jurisdiction. If there are no questions, I would rest on the brief.
Hearing none, you will have your full 5 minutes for rebuttal.
Okay, well, my name is Noah Munyer. I represent Mr. House, and I think Judge O'Brien was right. I reread all the documents in the last several days going over it, and I guess to me, it can't be a disputed fact because the facts are not in dispute. And the question is, citizens' rights are not obstacles to overcome. Their right to be respected. And we're talking about the Second Amendment here, and we're talking about a mens rea ability of somebody to understand what they're being charged with. I want to talk a little bit about a policy idea, that if this stands, if you can be charged with a felony, if lawful possession of weapons become unlawful from a misdemeanor warrant, then any time a warrant on complaint is issued in the state of Ohio, in Akron, a warrant on complaint for a minute, I text somebody a threat, and then they go to the police, and a warrant gets issued, and that person texts me and says, I just went to the police, and they're coming to get you. Now, all my guns at home are illegal, and I'm a felon. And so there is no mechanism by which I can raise my hand and say, well, come get the guns I have, because it's illegal for me to have them right now. And nobody called me and told me, and I don't have the ability to comply with the law.
But aren't there facts here in dispute? For example, if you don't turn yourself in on a warrant for 6 months, aren't there some facts in between to know if you knew about the warrant, should have turned yourself in, or?
Well, so, yes, Your Honor, so I don't believe they're in dispute because the ROI in our argument, our brief, and their brief admits that he says, yes, I knew about the warrant. Yes, I know I owe 3 days to Judge McKinney. So there's no dispute that he knew about the warrant. The question is, what does that do? And further...
Well, counsel, whether or not there was a dispute, the finding of facts or the representation of facts is in the realm of this dismissal motion for the defective indictment, correct?
Correct.
So how does that square with the state's argument that, the finding that, trial court's finding that there was nothing to find factually, therefore the indictment gets dismissed?
Because it's a legal conclusion. It's a status offense. Is somebody a fugitive from justice by the definitions under the case law and the statute?
Is there a pretrial motion or rule that applies where there is a dismissal pretrial?
We argue, obviously.
Like
Sorry.
this isn't a civil case where you have summary judgment.
Correct, and the state basically argued that in their brief that this was a summary judgment, and I guess Criminal Rule 12 allows that, and the judge found that, and the judge did it. And so I guess I would just argue that if this stands, if this is allowed to be charged, if this is the way that the statute was intended, one, that's not what it says. Citizens can't comply with it. We don't know where the definitions are. We, and the lawyers in this room, don't know where the definitions are. And so how do we comply? How does a person go from lawful to unlawful? And further, once he was arrested and charged with weapon under disability, he's no longer under a disability. So being under indictment for a non-disabling offense does not make you under a disability. So now he was under disability as a transient moment, and then once arrested and charged with a felony, his first felony, he's now no longer under the disability that got him charged with weapon or disability. And that just does not track.
Well, you can be temporarily under disability
You can,
if you're undergoing mental health treatment.
and it,
So that's, how is it different?
well, that requires a judicial finding, and you have to be under notice. There's a due process requirement. It's a Second Amendment right.
So he didn't get notice of his bench warrant?
Notice of a bench warrant does not translate to notice of, now I'm a felon and my guns are all legal.
And the fact that whether he had notice or not of a bench warrant would be a factual issue, correct?
There's no dispute that he knew about the bench warrant. He admitted it. So a factual issue that's not in dispute. That's all I have. Thank you.
I'll leave the balance of my time unless there are any questions. Thank you, Your Honor.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it's released, and they will also be posted on the Ohio